It's 4488. Oh, I didn't. Oh, sorry. Somebody stuck that probably under the door.
You could suggest it. You knew it.
Case number neglect 15519, police custodian in the matter of Mitchelle Blair and Matthew Berry.
Kelly Legacy, Assistant Attorney General on behalf of DHHS.
Rita Anthony, Foster Care Specialist, DHHS.
John Giancotti from CHAP, guardian ad litem.
Your Honor, Adam Devlin, attorney for Mr. Dorsey.
Alexander Dorsey.
Good afternoon, Laura Anderson, P51285. I represent the father, Stephen Berry.
Stephen Berry.
Good morning, good afternoon, Your Honor. Janice O'Burns, 35185. On behalf of Ms. Blair, which I'm assuming she's on her being brought around right now.
Good afternoon, Your Honor. Tracy M. Martin, P62745. I'm here at 711.
Okay, let's wait a moment, just want to bring Ms. Blair around and then we'll be able to see. Where would you put your name on the record? We were waiting for them to bring you up.
Can you say
Could you
again?
state your name for us?
Mitchelle Blair.
All right, we have everyone here, and we've completed closing arguments at this point, and so we are up to the court's decision regarding jurisdiction and whether or not there's a statutory basis for termination of each respective parent's parental rights. And so the court's findings of fact are as follows. We began this trial with a hearing under Michigan Court Rule M.3.972C regarding the video of Matthew Berry. The findings from his interview are as follows. He indicated that he saw his mother kill Stoney and Stephen, that with respect to Stephen, the mother beat him and threw him around. With regard to Stoney, that the mother was choking her, put her in the shower, and put alcohol on her. Matthew indicated he was being raped by Stoney, that he was urinated on. The mother found out what Stoney and Stephen were doing to him. In the course of the interview, Matthew showed marks that were on his back, stating that he was whipped by his mother with both a cord and a belt. He also stated that the mother had whipped Gabby and hit her with a hammer and a bar on Gabrielle's head. With respect to the father, Alexander Dorsey, he testified, he indicates that he lived with his mother most of his life, except for a period of 8 years when he lived with his girlfriend. He stated that he was currently unemployed for the last 2 years. Prior to that, he worked at Harper Hospital for approximately 3 years. He was unemployed by approximately 5 years prior to that. He's supported by his mother. He stated in his testimony that in 2005, he and his sister, who would be a paternal aunt to the child, saw whip marks on the back of Gabrielle and Stoney, that his sister called Children's Protective Services. He indicated that neither he nor the sister ever followed up with Protective Services. We had support orders and orders of affiliation or paternity admitted. Mr. Dorsey owes approximately $37,000 in back due child support. Mr. Dorsey testified that he did not follow up on Gabrielle or Stoney's school situation. He did not seek custody of either child from the court. He stated that between 2006 and 2013, there were sporadic visits. He said at one point in 2013, the mother stopped his visits completely. Indicated he was not concerned that he was seeing Gabrielle, but that he was not seeing Stoney. He said both Gabrielle and Stoney did not appear afraid. We also had photographs of the mother's home, the condition of mother's home, in disarray admitted. We then had testimony from Stephen Berry. The findings from his testimony are as follows. He lives with friends. He last worked at a temporary service in December of 2014. He was sentenced in December 2010 for a felony firearm conviction, along with felon in possession. He received a sentence of 30 months and was released in April of 2013. Child support orders and orders of affiliation for his children were admitted. Mr. Berry testified that he knew the mother since he was 18 years of age, that he gets food assistance. He did not speak to the child Stephen after his incarceration in 2010. He indicated that the mother told him that Stephen was mad at him and he did not want to speak to the father. Mr. Berry testified he did not seek parenting time from the court, that he's paid a total of $63.98 for both children in child support since 2007. He did not check to see if his two children were in school. He denied knowledge of any physical abuse, but acknowledged that he could have taken more steps to see his children. Said he was not aware of the 2005 protective services referral that came from Mr. Dorsey and Mr. Dorsey's sister. Said he did not see signs of abuse prior to him becoming incarcerated in 2010. We then had testimony from Dr. Carl Schmidt, a forensic pathologist with the Wayne County Medical Examiner. He was qualified as an expert in forensic pathology. The findings from his testimony are as follows. He indicated with respect to Stoney, the body had to be thawed because it was frozen. There were multiple scars over many of her body parts. She was beaten and or injured multiple times over a lengthy period of time. There was trauma or blows, as he indicated, to Stoney's head, trunk, and extremities. He indicated the cause of death to Stoney was blunt trauma, along with the numerous injuries, stating her entire scalp contained hemorrhages, resulting in swelling of the brain. There were burns on Stoney's body. Her ears showed an extensive loss of tissue. Dr. Schmidt indicated that every body surface for Stoney was covered with some form of injury or bruising that dated from weeks prior to death up to the time of death. He also testified that Stoney had chipped teeth, tears in her lip, and that she was found to be malnourished. The findings regarding Stephen, as testified to for Dr. Schmidt, were that his body was thawed, he was malnourished, there was multiple blunt trauma to his body with scarring. Dr. Schmidt indicated there was hemorrhaging to the head and scalp, blows that were merging together, burns to the body. Dr. Schmidt indicated there were parallel lines on the abdomen, back, and buttocks, second and third degree burns to the genital area, swelling of the brain, and Dr. Schmidt indicated the cause of death for Stephen was blunt trauma along with the burns. He also indicated that there was alcohol found in the presence of Stephen's bloodstream. Manner of death for Stephen was classified as homicide. We also had autopsy reports and pictures from the autopsy admitted. We then had testimony from Officer Carmen Diaz from the Detroit Police Department. The findings from her testimony are as follows. She responded to the mother's apartment on a police run. She saw a body in the freezer in mother's apartment. She observed the home conditions that are depicted in the photographs that were admitted to the court. She obtained a statement from the mother, which was admitted into evidence. We then admitted also medical records from Matthew and Gabrielle, along with school records for all 4 children. We had testimony from Katrina Hayden, a Child Protective Services worker with the Department of Human Services assigned to this case. She She testified there were 2 prior referrals regarding the mother, one in 2002 and one in 2005. The Children's Protective Services report, along with the family's first report, both completed in 2005 in connection with that referral, were admitted. We then had testimony from a Mitchelle Blair, a girlfriend of Mr. Dorsey. She said that she saw Gabrielle and Stoney at visits with Mr. Dorsey between 2005 and 2009. She said the mother did not allow visits for her after 2009. Testified that she never saw any injuries to the children, that the children never said anything about abuse, although she acknowledged that the mother was always present for those visits. Ms. Barrett indicated that she lived with the father, Mr. Dorsey, between 2006 to 2012. She was responsible for payment of rent, food, and the other living expenses. Indicated she was told at one point that Gabrielle and Stoney had marks on their backs. She stated in 2010 to 2011 there were only visits on the porch. Stated that Mr. Dorsey did not take action to see his children more often because the mother would not let that. We then had testimony from Victoria Johnson. The findings from her testimony are as follows. She resides in the Martin Luther King Apartments since June 2012. She was a friend of the mother who also lived in those apartments. Indicated she saw the mother, Miss Blair, daily since 2012. But every couple of months, the mother would indicate to her that she needed time, and then the mother went 1 to 2 months without seeing her. She stated that pattern happened approximately 3 to 4 times. In 2014, she stated she saw Gabrielle more often. Indicated she never saw signs of abuse to Gabrielle or Matthew. She never met Stoney or Stephen. She said she entrusted the care of her child to the mother, Miss Blair. Indicated that in her observations, Gabrielle and the mother were close, although she stated that she did observe the mother to behave aggressively on multiple occasions. Questioned as to how often, she indicated something under 5 times. We then had testimony from DeJuan Martin. He's the father of Miss Johnson's children. The witness who testified previously stated that he saw the mother, Miss Blair, and Gabrielle daily. He didn't see any marks or bruises to Gabrielle. He saw no concerns in his observations regarding the mother being abusive, and he denied telling the police that Matthew and Gabrielle appeared scared. The first question for the court to decide is there jurisdiction? The statutory section is MCL 712A2B. That would be paragraph either 1, 2, or both. Under paragraph 1, the court would have jurisdiction in this case. Both children are under 18 years of age. If the parent or other person legally responsible for the care and maintenance of the child, when able to do so, neglects or refuses to provide proper or necessary support, etc., or other care necessary for his or her health or morals, or who is subject to a substantial risk of harm to his or her mental well-being. That section would apply to both Mr. Dorsey and Mr. Berry. It also applies to the mother. Clearly, the siblings were at extensive risk of harm, but certainly Gabrielle and Matthew remained at a risk of harm. They were both physically abused, as indicated by the testimony and the legally admitted exhibits. They were without proper and necessary support. That applies specifically to Mr. Dorsey and to Mr. Berry, and certainly they were without proper custody or guardianship given the abusive environment that they lived in. So subparagraph 1 applies to all 3 parents. We also have subparagraph 2 where there would be jurisdiction at the home or environment by reason of neglect, cruelty, drunkenness, criminality, or depravity on the part of the parent or other custodian as an unfit place for the juvenile to live in. That section applies specifically only to the mother, as clearly the home environment for all 4 children, but certainly including Gabrielle and Matthew was an unfit place to live, based in part on the homicides of Stoney and Stephen, but in addition, there was physical abuse specifically to Gabrielle and Matthew in that home environment. So the court has jurisdiction. The second question on the court's for the court to decide today is there a statutory basis to terminate parental rights? And as indicated in closing arguments, each of the parties have a different interpretation on which sections would apply regarding termination of parental rights. So taking the mother first, the relevant section is MCL 712A.19B, subsection 3. The subsections that are applicable to the mother under that provision of the law would be B(i), which indicates that the child or a sibling of the child has suffered physical injury or physical or sexual abuse under one or more of the following circumstances, and subsection I specifically states the parents act to cause the physical injury or physical or sexual abuse, and the court finds there's a reasonable likelihood the life of the child will suffer from injury or abuse in the foreseeable future if placed in the parent's home. Well, with respect to the mother, we really have both portions of that statute. Number one, we have the fact that the siblings, Stoney and Stephen, were in fact killed by the mother, and so clearly they've suffered more than physical injury or physical abuse. But in addition to that, we have the physical abuse to both Gabrielle and Matthew, excuse me. Matthew, even in his DVD interview, showed the interviewer the scars that he had, the marks that he had on his body. We have exhibits and testimony showing that Gabrielle was also physically disciplined and physically abused. So we clearly have, by clear and convincing evidence, had B.I. as to the mother. We also have G as to the mother, which indicates the parent, without regard to intent, fails to provide proper care and custody for the child, and there's no reasonable expectation the parent will be able to provide proper care and custody within a reasonable time, considering the child's age. We have that with respect to the mother. Clearly, there was a lack of proper care and custody for all 4 children, but with respect to the 2 surviving children, clearly the abusive environment they lived in constituted a failure to provide proper care and custody. That's demonstrated by the testimony, by the medical records, by the autopsy for the other 2 children, by the school records. That's established. We also have subparagraph J for the mother. There's a reasonable likelihood based on the conduct or capacity of the child's parent. The child will be harmed if he or she is returned to home with the parent. That's certainly true of both Gabrielle and Matthew. They've been harmed already on multiple occasions, and there is more than a reasonable likelihood they would be harmed if returned to that environment. Also, with respect to mother, we have subsection K. The court finds that we have 2 subparagraphs under K. We have III, which is battery, torture, or other severe physical abuse, which has already been indicated on the record, both by the exhibits admitted and also by the testimony given along with the mother's statement to the police that was admitted. We also have 6, which is B(i), under subparagraph K, which is murder or attempted murder. The siblings, Gabrielle and Stoney, which is part of the analysis, were both murdered by the mother. The court doesn't find necessarily that we have 4, 5, or 7, because those aren't really cumulative. They're already included in the fact that we have 3, and certainly we have 6, which is murder or attempted murder. So those are the statutory basis for the mother. With respect to Father Dorsey and Father Berry, the question of whether there's a statutory basis to terminate their rights is a little different than the mother, because the allegations as to them are a failure to protect, a failure to provide for their children, and so the statutory basis are somewhat different that would apply to them. But the court does find a statutory basis for Mr. Dorsey and Mr. Berry under B(i), which reads as follows. The child or a sibling of the child has suffered physical injury or physical or sexual abuse, which is true of all 4 children in this case, including the 2 deceased children. And B(i) states, the parent who had the opportunity to prevent the physical injury or physical or sexual abuse failed to do so, and the court finds that there's a reasonable likelihood the child will suffer injury or abuse in the foreseeable future. The bottom line is, the point, and I think it was made by the child's attorney, is how do you not know if one of your children is deceased? And that is telling. It's not as if this situation involved one isolated event of abuse. The dates back as far as 2002. And while respondents make an argument that Protective Services was involved, that Protective Services could have done more, that has no bearing on the individual parent's responsibility to follow up, to be aware, to provide care for their child, to make sure their child is safe. And this pattern existed over approximately 13 years. And granted, the situation worsened and worsened as it went on. We had an event in 2002, then we had a 2005 referral that Mr. Dorsey and his sister indicated that they called in, and then we have one child who we now have determined was killed in 2012, another child killed in 2013, along with the continued physical abuse of Gabrielle and Matthew. There is no way that a parent could not know of some of that. Even if you were to argue that you didn't know about a particular event that happened, there is no way that a parent could be oblivious to all of those things. It is too much. It goes over too long of a time period. Any parent who was involved in their child's life would know if they were physically abused, would know how they were doing in school, are they going to school. There's just too much there for a parent to say that they didn't have knowledge, that there were issues that required their intervention, their protection, their parenting. And so the court finds that the evidence is clear and convincing that we have BII for both Mr. Dorsey and Mr. Berry. We also have, as we did for the mother, subsection G for Mr. Dorsey and Mr. Berry, which indicates that a parent without regard to intent fails to provide proper care and custody for the child, and there's no reasonable expectation the parent will be able to provide proper care and custody within a reasonable time. At this point, neither Mr. Berry nor Mr. Dorsey have really ever cared for their children on a full-time basis. There's testimony of visits, sporadic visiting for both of them, albeit a different pattern between Mr. Dorsey and Mr. Berry. But even the testimony of each father, in their own words, Mr. Berry at this point lives with friends. He's not employed. He's not able to pay any child support. He hasn't paid any child support. Mr. Dorsey is primarily supported by his mother. He was last employed about 2 years ago. He doesn't pay child support because he indicates he doesn't have the money to pay child support. The bottom line is the court couldn't return Gabrielle to her father and Matthew to her father today because they're not capable of providing proper care and custody, because they don't have permanent housing, they don't have employment, they don't have the funds to support their children. So we clearly have G with respect to them, and there isn't a reasonable expectation that either parent would be able to do so in the future, because this pattern has gone on for years where fathers visit, then there's a gap, and we could argue for days as to whether or not the mother interfered with their visits, the mother didn't, but it's been years where these fathers have never really had either of their children in their custody. So we have G. The agency argues for AII that the child's parent has deserted the child for 91 or more days. The court's not going to make a finding under AII for Mr. Dorsey and Mr. Berry. There was a great deal of testimony regarding visits, when they did visit, when they didn't visit, when the mother stopped them from visiting, when they could visit, when they visited on the porch. And while there is some testimony that there were gaps in there that may or may not have exceeded 91 days, the standard is clear and convincing, and that part of the testimony was not as clear-cut as it needed to be, so the court doesn't make a finding under AII. And so the court at this point will continue the matter for a best interest hearing with respect to all three parents for testimony that they may wish to present, so the court can make a determination whether termination of each respective parent's rights is in that specific child's best interest, and that may or may not be different with respect to each child. So, Ms. Megacy, we're going to need psychological evaluations for both Gabrielle and Matthew, and then with respect to Mr. Dorsey, Mr. Berry, Ms. Blair, I'll start with you, Mr. Devlin. Is your client willing to participate in an evaluation so that we can have background on where he stands and what the relationship is with his child?
Oh, yes, Your Honor.
And what about you, Ms. Anderson?
Yes.
And Ms. Burns?
Yes, Your Honor.
Have we made any arrangements to start the process on that, Ms. Mason?
We have, Your Honor, evaluations have already been done of the children, and we've had discussions with counsel. Obviously, we didn't know what the court findings would be, but we have a trauma-based therapist who has evaluated the children, who is willing to do the evaluations on the fathers, and I believe both fathers' attorneys are agreeable to that happening, that occurring with Dr. Henry, James Henry.
So he's a private psychologist
Yes.
that we're using?
That's fine, Your Honor. I just ask that not only does my client be interviewed alone by the doctor, but that he observe my client along with his son.
And again, I would order that for actually both fathers, that we have some observed parenting times or to make a decision as to what relationship, if any, exists between Mr. Dorsey and his child and Mr. Berry and his child.
Your Honor, just as it relates to Gabby, she's not electing to have parenting time right now, so I don't think that we should force her to have to participate if she doesn't wish to.
Well, there hasn't been any parenting time by her choice.
Correct.
But for purposes of doing the psychological evaluation, I think it's a necessary component. So the doctor's going to interview her anyway, individually. And
I think
so
that's already done, though.
it's already done her interview.
Her interview has already been done, correct?
I would ask, though, that in the course of doing Mr. Dorsey's interview, we have Gabrielle participate. And that's not for that lengthy of a time. It's in a supervised setting, and we're going to need some barometer on what, if any, bond or relationship exists between Mr. Dorsey and Gabrielle.
I would just, leave that to the discretion of the doctor, Your Honor. If he's already interviewed my client, I don't know that it may or may not be necessary. And just based on the fact that she may have revealed to him what her desires are, based on her age, I think she can express that, and I think the court should leave that to the doctor's discretion if he feels it's necessary.
Well, she's going to be 18 soon.
Yes.
So certainly the court respects her wishes regarding whether or not she wishes to visit at this time. But I don't know how we can get any benchmark if the doctor can't observe the two of them together in a clinical setting.
I understand, Your Honor. I'm just advocating on behalf of the child and what I believe her desires are at this time.
Ms. Megacy, any input on that?
I would echo what counsel has stated, because while I recognize that their interaction is a consideration for this court, I think the court already has substantial evidence on the record regarding the bond or the lack of relationship that this man has with the child. And I don't have anything further to add.
Ms. Anderson, any statement? There's no objections from Mr. Giancotti.
As to Matthew.
To visit Matthew and Mr. Berry.
So I would have no statement regarding Mr. Dorsey and his child.
Yeah, the court's going to ask Dr. Henry to view them together. It's clinical, and I understand that if Gabrielle certainly doesn't want to visit or have an interaction with Mr. Dorsey outside of the clinical interview, but I would like him to have Gabrielle participate in the interview so he can, in his report, incorporate some of his findings that may or may not be apparent without having Gabrielle there. And that may not just involve Mr. Dorsey and Gabrielle being in the same room, but it also may require some follow-up from Gabrielle that the doctor needs to conduct with her individually after he completes the evaluation of Mr. Dorsey. So I would ask her to be there. Anything else we need to do for this record today? We'll start with you, Ms. Maxine.
No.
We have a date for July 27 at 9:30. Do we know if that's adequate time at
It
this
is
point?
adequate time.
For the doctor to
Yes.
complete his report?
Yes.
Mr. Giancotti, anything else?
Nothing.
Mr. Devlin?
No, Your Honor.
Anderson?
Yes, I would just ask that as soon as the doctor's report is available regarding my client and his interaction with Matthew, that it be presented to me. And that if there are any other exhibits that any party wishes to introduce, that I have those as soon as possible.
Well, there's already an order out there for reciprocal discovery. That would include the exhibits. The report would be provided to the court. And so I don't know what his timetable is, Ms. Megacy. Have you discussed that with him?
I haven't gotten an exact timetable, Your Honor. What I can do is I will forward Dr. Henry's information to counsel. He knows that he and the staff know that we're concluding today, or we're expecting to conclude today, and they know about the 27th being the next court date. I don't know what the attorney's intentions are in terms of these interviews, if they want to speak to Dr. Henry before, or just, I will, though, provide counsel with his number and name, and I'll contact him myself in terms of when he can have that actual report done, but I don't have that exact timetable today, no.
The court will
Your Honor,
make it easier, the court will set a date.
I'm sorry to interrupt you, Your Honor, but I just want to make sure Ms. Blair wants to be involved in the evaluations. So, giving me the doctor's information, I don't know how that's going to be helpful as she is in the Wayne County Jail. So I would ask that her information be given to him so that he can contact the jail and schedule a time convenient for himself.
It raises an interesting tactical issue, because Dr. Henry's going to have to come to the mother at her placement to interview her for the clinic.
And I have not discussed that aspect of it with Dr. Henry or his staff as of yet, so I will do that today, or whenever I can get contact with him as soon as this court hearing is over. The problem I've run into, though, is that when that does happen in terms of the clinic conducting evaluations of parents who are incarcerated, typically they bring that parent to the courtroom or to the courthouse, that way the person can interview. I don't know what this court's procedure is.
We don't have that option here, because Dr. Henry is a private psychologist that the parties have agreed upon, so.
I will contact the court staff, I will contact Dr. Henry and his staff. If there are any problems with that, I will notify the court immediately.
Just make sure that you have adequate contact information
Yes.
for the mother to pass on to him. And what the court will do is the court will set a date for Dr. Henry's report to be submitted to the court. If any other party doesn't have it, then you can certainly pick up a copy from the court after that date. And so our court date is July 27th, which is 1 day short of 4 weeks away. So I will put in the court order that Dr. Henry's report will be due July 21st, which is 3 weeks from today and 6 days before the court hearing. Any party that doesn't otherwise have a copy of it or is unable to get it can come to the court, and we will provide a copy to any of the attorneys that don't otherwise have it.
Thank you, Judge.
Anything else?
No, thank you.
We'll adjourn. Thank you. Can you give me the full spelling of Dr. Henry's name?
Jane, regular, and Henry.
Henry. Henry.
Yeah.